Hi everyone, my name is Irina and this is a video presentation for Kulko versus Superior Court of California case. I apologize in advance for any noise, maybe the wind noise, or if anyone will pass by me in swimsuit, because I'm recording this little video out from the Dominican Republic where I spent my time, my spring break time. So let me go to my PowerPoint here. Okay. Okay, so this is Ezra Kulko versus Superior Court of California, 1978 Supreme Court case. A little bit about syllabus of this case. Appellant and appellee are former spouses, Ezra Kulko and his wife, Sharon Kulko Horn, who were married in California in 1959 during a very short 3 days stopover while the appellant was en route to his overseas military duty in Korea. After getting married, he went to Korea, of course. She went to New York, and they both returned to their residence in New York later. Their kids were born in New York. The family kept living in New York for the entire duration of marriage until they got separated 13 years later. After signing the separation agreement, which was, by the way, executed in New York, Appealee moved to California. According to separation agreement, both kids were to remain with father except for Christmas, other holidays, and school breaks, which they were to spend with their mother in California. Appellant was to pay $3,000 a year to Appealee as a child support for the time she takes care of kids during holidays and vacations. After separation, the Appealee went to Haiti, got a divorce decree there, and then remarried again. About a year after the separation, one of the kids, daughter, asked her father to let her live with mother, to which he consented and bought her a one-way ticket to San Francisco. Soon after, the appealee, Sharon, without notifying the appellant, has arranged her son also to move to California for the purpose of living with her. And then she brought a suit against the appellant in California court, where she was then domiciled, to establish a Haitian divorce decree as a California judgment, and to modify the judgment as to full custody of both kids, and to increase the child support obligations of the appellant, who was then still domiciled in New York. So, of course, he moved to dismiss the claim, based on lack of sufficient minimum contact that was required for personam jurisdiction to be established over him by California court. Because according to the International Shoe Company versus Washington, the Supreme Court case of 1945, in order to render the judgment for plaintiff against a foreign non-resident defendant, court has to have a right to exercise the personam jurisdiction over the defendant, and minimum contact with a forum state would suffice for this purpose. So the trial court and the appellate division court have decided to ascertain the personal jurisdiction over defendant, and California court's decisions were based on next factors. First, California should exercise personal jurisdiction over a foreign defendant for any reasonable cause. Here, the appellant has caused an effect of minimum contact in the state of California by letting his daughter to live with appellee, a California state's resident. And California has a legitimate interest in protecting the well-being of their kids and increasing the child support obligations. Supreme Court decision, however, reversed California court's decision based on next: exercising of personam jurisdiction over the defendant, who is domiciled in foreign state, never moved to California for the purpose of residency, had no other contacts whatsoever with California except for a few days stopover almost 15 years ago, even though at that time they got married in California. Still, exercising of personal jurisdiction over such defendant would be violating the Due Process Clause of the 14th Amendment of the United States Constitution. Second, if mere acquiescence of the father to let his daughter to live with ex-spouse would constitute a minimum contact requirement for the purpose of personal jurisdiction over the spouse and would later be able to drag that person to another state for his or her own defense in front of another state's court, that would be harshly burdening a familial relationship that is already hard enough after the divorce. The appellant in this situation, as Supreme Court explained, had no economic benefits gained from this situation. He did not get any economic benefits from the fact that his daughter moved to California state. Rather, his benefits were tied to the fact that he was out of New York state and he had to spend less money for her support. But overall, this entire situation was not an economic transaction. It was more like a family domestic relations situation. And the third factor was regarding legitimate interest of California. The legitimate interest in California in supporting their minor residents, Supreme Court explained, was already served because California was participating in the Uniform Reciprocal Enforcement of Support Act of 1968, in which California is a signatory. This act permits California residents to claim support, child support, from a non-resident and have this decision to be adjudicated in the obligor's state without either party having to leave the state. And by the way, New York state have also joined the similar statute, so there was no need for Mr. Kulko to travel all the way down from New York to California, be actually dragged from his domiciled state to California to support his claim or defend himself in front of California's court. In other words, California had no personam jurisdiction over Mr. Kulko, so their decisions were illegal, and that's why the Supreme Court reversed. There was also a little short dissent I wanted to mention. It was a very short dissent of Justice Brennan, who in general agreed that before exercising personal jurisdiction over a non-resident parent of minor domiciled in the forum state, it must appear that the non-resident has certain minimum contact with the forum state, such that the maintenance of the suit does not offend traditional notion of fair play and substantial justice. However, Justice Brennan's personal opinion on the matter was that the defendant's contact with California wasn't that attenuated, and under the standard of reasonableness and fairness of the Due Process Clause, he said Mr. Kulko should have been required to defend himself in front of California's court. And this is it about the case. Let me go back to my video so I could say goodbye, and see you in class.